Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, Contracts Overview, from Formation to Remedies. Let's begin. Contracts is a story of promise enforcement. On the bar exam, ask 5 questions in order. Was a contract formed? What are its terms? Is there a defense to enforcement? Was performance due and breached? What remedy follows? The MBE tests both common law and UCC Article 2. Common law governs services, land, employment, and most non-goods transactions. UCC Article 2 governs transactions in goods. Goods are movable things at the time of identification to the contract. Mixed contracts are usually governed by the predominant purpose test unless the contract divides payment between goods and services. California essays may test common law and UCC principles plus California-specific doctrines, such as the covenant of good faith, unconscionability, and remedies. For MBE purposes, use majority common law and UCC rules. Contract formation generally requires offer, acceptance, consideration, and no valid defense. Some promises are enforceable without traditional consideration under promissory estoppel, restitution, or special statutory rules. Offer. An offer is a manifestation of willingness to enter a bargain that justifies another person in understanding that assent will conclude it. The more definite and committed the language, the more likely an offer exists. Advertisements are usually invitations to deal unless they are clear, definite, and leave nothing open for negotiation. Acceptance. Acceptance is assent to the offer's terms. Bilateral contracts invite a promise. Unilateral contracts invite performance. Under the mailbox rule, acceptance by an authorized medium is generally effective upon dispatch, while revocations, rejections, and counteroffers are effective upon receipt. Consideration. Consideration is a bargain for legal detriment or benefit. Courts generally do not examine adequacy, but a sham or nominal exchange may fail. Past consideration is not consideration unless a modern exception applies, such as a new promise to pay a debt barred by limitations in some circumstances. Mirror image rule. At common law, acceptance must mirror the offer. A purported acceptance with different or additional terms is a counteroffer. UCC flexibility. Under the UCC, a contract for goods can be formed even if terms are open, as long as the parties intended to contract, and there is a reasonably certain basis for a remedy. Quantity is usually the essential term. The UCC supplies gap fillers for price, delivery, payment, and time. Battle of forms. Between merchants, additional terms in an acceptance may become part of the contract unless the offer limits acceptance to its terms. The new terms materially alter the contract, or the offeror objects. Different terms are handled by varying approaches, including knockout rules in many jurisdictions. Merchant firm offer. A signed writing by a merchant assuring that an offer to buy or sell goods will be held open is irrevocable for the stated time or a reasonable time, not exceeding 3 months, without consideration. Capacity. Minors, mentally incapacitated persons, and intoxicated persons in limited circumstances may avoid contracts. The vulnerable party usually has the power of avoidance. Mistake. Mutual mistake about a basic assumption that materially affects the exchange may make a contract voidable by the adversely affected party if that party did not bear the risk. Unilateral mistake is harder. Relief generally requires that enforcement would be unconscionable or the other party knew or caused the mistake. Misrepresentation and fraud. A contract may be voidable if a party justifiably relied on a material or fraudulent misrepresentation. Fraud in the execution may make an agreement void. Fraud in the inducement usually makes it voidable. Duress and undue influence. Duress involves an improper threat, leaving no reasonable alternative. Economic duress requires more than hard bargaining. Undue influence involves unfair persuasion of a vulnerable party by someone in a position of trust or dominance. Unconscionability. Unconscionability is assessed at contract formation and often includes procedural unfairness plus substantive unfairness. Courts may refuse enforcement, sever a term, or limit application. Illegality and public policy. Illegal bargains may be unenforceable. If the illegality is minor or one party is protected by the statute, restitution may be available. Parole evidence. The parole evidence rule bars prior or contemporaneous extrinsic evidence offered to contradict or supplement an integrated writing. A complete integration cannot be supplemented by consistent additional terms. A partial integration may be supplemented, but not contradicted. Evidence may be admitted to interpret ambiguity, show defenses, prove conditions precedent, or establish later modifications. UCC interpretation. The UCC gives weight to course of performance, course of dealing, and usage of trade. These can explain or supplement terms unless carefully negated. Conditions. A condition is an event that must occur before performance becomes due, or that cuts off a duty. Express conditions require strict compliance unless excused. Constructive conditions generally require substantial performance. Common law performance. For services and construction contracts, substantial performance usually triggers the other party's duty to pay, less damages for defects. A material breach excuses the other party's remaining performance. UCC perfect tender. For goods, the seller generally must make perfect tender. Goods and delivery must conform exactly. But the UCC provides cure rights, installment contract rules, and acceptance/revocation doctrines that soften perfect tender. Expectation damages. The standard remedy is expectation. Put the injured party in the position as if the contract had been performed. Damages must be foreseeable, certain, and unavoidable through reasonable mitigation. Equitable remedies. Specific performance may be available when legal damages are inadequate, especially for unique goods or land. It is generally not available for personal services, though negative injunctions may sometimes prevent competing services. Always choose common law or UCC before applying formation and breach rules. Do not use the mailbox rule for option contract acceptances unless the option permits it. Acceptance under an option is usually effective upon receipt. Consideration requires bargain, not fairness. Parole evidence applies only to prior or contemporaneous terms, not later modifications. Perfect tender is the UCC starting point, but cure and acceptance often change the result. Contracts questions often bury the issue in chronology. Mark the timeline: offer, termination, acceptance, writing, modification, breach, mitigation. Then identify the governing law. If you know where you are in the timeline, the rule becomes much easier to apply. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.